for those of you that aren't familiar with collaborative divorce is essentially, collaborative practice allows us to resolve disputes without going to court. We intentionally work towards a positive outcome for both parties and their children. We use transparency and cooperation rather than some of the traditional adversarial tools and techniques. And what I really like about collaborative and what I tell clients is that it empowers the participants to really be a part of crafting this solution. Oftentimes when people are going through divorce, they feel very detached. We turn this stuff over to a lawyer and then it becomes about that process. And it detaches them from something that's their life. And you know, this is our job, but this is their life. They're the ones that have to live with this down the road. So collaborative lets us have a little more practical solutions. So in the collaborative framework, both sides are represented by counsel, but everyone agrees that we are going to negotiate in good faith towards an acceptable solution for everyone. In the collaborative practice agreement, one of the things that is unique is that the lawyers are disqualified from any future litigation. So if the wheels completely come off this bus, which is very rare, but not impossible, if those wheels completely come off the bus, then both lawyers have to withdraw from the case and the parties find new attorneys to go to trial. And we'll talk a little bit more about the details about that later. Clients agree to avoid or suspend litigation. Usually when collaborative cases come to us, we start out from the beginning in a collaborative mode. And so we may discuss as a group how we're going to file, when we're going to file, but it can also happen if the case has already been filed and the clients decide that they want to switch to a collaborative method, we can do that. Each person has independent counsel, so you still have attorney-client privilege, you still have that one-on-one relationship, but everyone actively participates in the negotiation. Discovery is another thing that's different in collaborative. In discovery, if everything is shared willingly, openly, transparently, there's no hide the ball. We will often give clients homework. Here's what we need to have. We need your pay stubs. We need to have the tax returns the last few years. We need to know where everyone's accounts are, where the 401ks are, what's the value on the house. We agree up front that we're going to share all that information because it's got to come in. We've got to have that information to make an accurate decision. So we're not going to waste a lot of time hiding the ball. Any experts that we use are jointly retained, and they are disqualified from future litigation unless the parties agree otherwise. For example, if we have a couple that has a shared business that we now have to figure out how we're going to divide in the divorce, we may have a neutral expert come in to give us a valuation. If they were to go to court down the road on another issue, they may say, yeah, we still agree on what this valuation is, so we don't have to hire new people. We can also use other team members in collaborative divorce. It may be a CDFA, which is a certified divorce financial analyst, if you're not familiar with that. A child specialist, a divorce coach. Divorce coach is someone that would be used just by one party to help them get through some emotional issues they're struggling with the divorce, help keep them on track, help them feel a little bit more secure in the process. The other team members are usually utilized jointly by the parties. So if we have young kids, we're not sure what's the best visitation schedule. I've sent people to one of our child specialists to help them understand developmentally what's best for these kids at this age. How often do they need to see each parent? When does that change as they get older? Things like that. There we go. So in this team approach, it allows us to serve the common purpose of getting to the best result for everyone involved. These families have to live together afterwards, not technically together, but the relationship lasts beyond the divorce. So if you have kids, you are going to have the same graduations, the same weddings, the same grandbabies, and we want that relationship to be positive. We don't want the kids to have to worry about the baggage from mom and dad's divorce when they're planning their wedding and how are we going to get through the reception without a big blow up. The team approach allows us to meet people where they are. Oftentimes in divorce, people come into this at different stages in the grief process. Those that have decided that it's time to get divorced often have gone through the stages of grief during the marriage. Those that did not make that decision can often feel blindsided, and they still have to do their processing emotionally. And that's not something that you can force. We can't push through that. We've got to meet people where they are and give them the time to process, because that allows the healing to start. The team approach lets us level the playing field. Everyone knows the same thing at the same time. So that takes the stress off the people, and it takes the stress off as they're parenting together through the divorce process. We don't have to worry about what some scary attorney is doing behind the scenes, because they've met both of us, and they develop a relationship with both attorneys and a level of trust with both attorneys that you don't have in a traditional case. The information's neutral. It is what it is, and facts are what they are. Valuations are what they are. There can be some fudging and a little bit of back and forth, but we can talk through where those numbers come from, why they're valued the way they are, and find an agreement that everyone can meet in the middle on. Using a team approach also allows us to model teamwork for the participants. In our Central Iowa group, all of us are trained mediators as well as being trained in collaborative. So we understand how to have difficult conversations. We understand how to talk about interests, how to separate the issues from the people, how to not make it personal. So as the clients see the attorneys talking to each other respectfully, still making our point and making sure our clients' concerns and interests are addressed, but doing it in a respectful manner, doing it in a productive manner, we're modeling that behavior for our clients, because in order to help them communicate better, to break those bad habits, we've got to give them good ones. And usually if people have great communication habits, they don't end up in a lawyer's office. So that's usually an issue, an area where we can help. So in an overview, there are other team members we can potentially use, but the main ones are the attorneys. Like I said, each person has their own attorney. That attorney is going to be able to advise them, be able to help them clarify what their interests are, what they really want to get out of this, because sometimes clients come in with kind of stereotypical ideas. I need to get the house. Okay, well, let's talk about that. So 6 months from now, if your job's the same as it is now, can you afford the house? Well, I don't know. Well, then maybe that's not the best plan. So let's talk about what I always tell people is that I want your life to be better at the end of this. We need to have you to a place where you are ready to move forward in a positive manner. You're ready to, you have a solid foundation to build your future from. And sometimes the traditional win that we think about in divorce doesn't always do that. I had a gentleman, he said, well, what does the wife do if she gets the house? Well, if she can't afford it, she sells it in 6 months, and now you're back to turmoil and we haven't really gotten you any farther. So in collaborative, because we are so focused on the better solution for the family, we need two parents that are financially stable, that are emotionally stable, because that's what's going to be best for the kids. And so we have that higher solution in our mind instead of just going for the win traditionally. They have that one-on-one time. What I always tell people is sometimes there are things that we really need to say that we really don't need to say in front of the other people. And that's okay, because it is emotional and you're going to be processing through a lot. Come vent to me. Dump it all on, bring it on me. I'm going to help you work through it. And then when we go into that room, we're going to stay on the high road. And I had a case where the other client actually was getting a little bit snarky, we'll say, and saying some things that weren't helpful. And his attorney said, listen, let's take a break, get a drink of water, just kind of take a walk. And she took him outside and said, stop. You need to stop doing this. You told me when we went in that you want to have a good relationship. This is the mother of your kids. What you're saying there is not helpful to that goal. And he thanked her, and we came back in and we were on a much better field. So you have attorneys that are using our powers for good, for lack of a better way to put that, using that influence to really be able to help clients get to a better place. Mental health professionals can come in, as I said, with a coach, with a child specialist. I've had some clients early in the process that are kind of on the fence about divorce. We're not sure. We think we're there. We're not positive. There are therapists in Des Moines that do what's called discernment counseling. In discernment counseling, it's a very specific process that takes place over 1 to 3 sessions, and the therapist will help them work through, is this something that we're really ready to be done with? Do we want to stick it out and do therapy and make one more try and see if we can stay together? Or do we just need more time to process? But they will help them come to one of those 3 solutions. And so I've had people that have done that and gone on to counseling, and I've had people that have done that and come back to collaborative divorce. But being able to address the mental health, the emotional, all of the turmoil that's involved in this huge life transition is really valuable. And it's what I see from clients when they see that the attorneys understand that, and not just their attorney, but the other attorney. When we go into that 4-person meeting with the clients and the attorneys, and they can see that there's empathy across the table. They can see that this isn't a scary person who's out to get me. And they uniformly, they understand that they are each represented by someone, but having that empathy and compassion in the room really decreases the anxiety, which increases their ability to communicate. And we understand that sometimes we need to have a mental health person come in, or we may send the clients to them to talk about stuff with the kids. Maybe there are parenting issues that have come up, something that's happened in the past, and we're just having trouble getting past it to rebuild the trust that we need to have them successful going forward. So we may proactively say, listen, do some parenting planning with a counselor, have them work through that therapy with you. We have proactively used parenting coordinators. We know we've got you to a good agreement. If it works, you're both going to be happy, but there's a little uncertainty about how it will play out. Just plan on going to a parenting coordinator once a month for the first 6 months while you get your kind of post-divorce sea legs. And usually whenever we can add in those other resources, it makes clients feel better. We also use financial professionals, certified divorce financial analysts, business evaluators. I love using CDFAs in collaborative. My favorite story that I tell is we had a case where the wife had stayed home with the kids, was now working part-time, looking for full-time work, but was pretty sure in her mind coming in that she needed spousal support. And so we turned all of their financials over to the CDFA and come into the meeting, and what they will do is put everything into their software, into their charts, and bring this in and shoot it up on the wall. We'll have a projector in there, so everyone sees the same thing at the same time. Everyone sees what all of the numbers are. And in this case, there wasn't a ton to work with, and looking at their budgets, and then we'll talk about budgeting as well, because that's great. You get the house and you have $100,000 on paper, but that's not cash flow. And so it's important to be able to have those conversations about cash flow as well as just equity numbers on the spreadsheet. So in this case, they came in and we talked through the budgets, and she was going to be, when you added in health insurance, things like that, she was going to be about $1,500 in the hole. He was only $800 to the good on very, very frugal budgets. So, and half of that would be child support, but even if we moved everything over, she was still going to be $700 in the hole. And so now all of a sudden, alimony doesn't solve our problem, but she also knows that he's not being a jerk. There's nothing there. And so I watched, and then we started brainstorming. So now that's off the table. So let's brainstorm. What are our plan Bs? What's plan C? What are other ways that we can get her some cash flow and cover this gap to get her back on her feet. And it completely changed the conversation. And over the course of 2 hours, I watched this sweet woman go from tears to empowered. And now she has a plan and she's making phone calls. And it's because we brought those numbers in. We had someone neutral explain them. We walked through cash flow. We walked through tax implications. We walked through refinancing options, debt options. They had data, you know, information is power, knowledge is power. And so when we bring in more information, more knowledge for these clients, now they're making decisions based on facts rather than their feelings. So it's very helpful to have that. It's very helpful to have when you have complex, some of these farms, businesses, things like that, to be able to bring in a neutral evaluator. Let's talk through different scenarios and then let the clients choose what fits their goals and values best. So the process itself, when each client has retained their collaborative professional, the first thing that we'll do is set up a joint meeting. And that meeting starts with signing the participation agreement. It is a very long document, but what it goes through are the ground rules. It talks about that we are entering this process to avoid going to court, to avoid the expense and both financial and emotional expense of going to court. This process is designed to work with integrity and dignity and respect and transparency. We are going to talk to each other here and not take these conversations outside the room unless we both agree to. It talks about the needs of the kids and how we're both going to leave the kids out of this, not talk about this around them. We're going to respect their feelings and emotions and do what's best for them. Talks about the agreement that we understand that we need to both be financially stable at the end of this. It lays out the requirements for the attorneys to, if there's an abuse of the process or if someone has to withdraw from the case, how that's dealt with. We go through how we address temporary agreements. You can still have those. Sometimes we need a temporary agreement for visitation or child support. How do we address those in here? When do we want to file documents? Documents don't get filed unless everyone agrees. So we go through all of that agreement. That's the first part of that, is signing that agreement. And then what we do is turn it over to the clients. We always start this process with asking the clients what their goals and values are. What do you want life to look like? What are the things keeping you awake at 2 a.m. that we need to address? And it can be as simple as, you know, we don't want to hurt the kids. We want the kids to get through this as smoothly as possible. We absolutely want to be able to keep the house, or we both need to be able to get into new homes. I had one couple that they didn't want either one of them to have to leave the church. You know, we don't want our friends to have to choose at the end of this who they're still friends with. So some of it are legal issues, but some of it are just the messy human emotional issues. And we need to be able to talk about those because that's often the driving force. We don't make all of our decisions in this calm, cool, linear fashion. We're driven by the messy human stuff too. And the collaborative process creates a safe space to address those concerns as well. Excuse me. We will talk about, are there any immediate issues that we need to address? Have the kids been told? If not, are they comfortable doing that? Do they want to talk to a child specialist before they do that? Where are they in that process? Do we want to get paperwork on file right now, or do we want to wait a little bit? In other jurisdictions that have adopted the Uniform Collaborative Law Act, there'll oftentimes be a waiver. So the clients may be in the process for 90 days or 120 days, but the paperwork doesn't get filed with the court until the end. here we still have our 90 days. So we talk to clients about whether or not we need to get something on file because we've got to get the ball rolling because someone's gonna have to refinance. We're gonna need something in place there. Or do they want to wait? And who wants to be the one to file? A lot of times they don't, it doesn't really matter, but in some cases it really does, that one person absolutely does not want to be the one that files for divorce. Those are all the things that we address in those immediate issues. If one of the parties has moved out, do we need a temporary agreement for how the kids are going to be shared at this point? Whatever we need to do, we address those issues up front, and then we start talking about the larger issues. Sometimes parents want to go through the kids first. Sometimes they want to talk about the finances first. My rule of thumb is what's keeping you awake at 2 a.m. Because if I can address what's keeping you awake in the middle of the night, that's going to take that stress off of you, and everything else we have to discuss is going to be an easier conversation. So we'll identify the order that we want to address the various issues in, and then we'll start making a list of homework. What information do we need? We need the pay stubs, we need the taxes, we need the account statements. We may need to talk to a realtor, or we need to talk to an assessor to get a valuation on the house or the boat or whatever it is. And we will make a list of homework and who is going to be assigned to which task, when we need to get it done by, and that's what the clients will leave with. So instead of attorneys going back and forth and sending pages and pages and pages of discovery, the people, the clients are empowered to do this, and which obviously saves cost. But I think the more valuable part of that is that they have something to do. It's very nerve-wracking to feel powerless, to feel like you just turned it over to somebody. If I have my list to check off, I have something to do. Now I am engaged and invested in this process, and if I'm doing something, I'm less anxious. So that's part of the value too. And for the person who, because usually one party does more of the finances in the marriage than the other, for that other person, now this is getting them knowledge and information they're going to need as they prepare to figure out their own financial life going forward. So it gets everybody involved in the information at the same time. We may take that time to send them to a mortgage originator, to send them to a realtor, to send them to whatever resource we need for them to get a little additional information to come back to the group with. And then our meetings are a series of brainstorming, testing possibilities, especially where the kids are involved. So we may say, listen, let's try parenting time A and see how that goes, especially where maybe one parent has been the primary caretaker, stay-at-home parent, but we want to get to a place of shared care. Well, we don't want that to be jarring for the parents or the kids. So let's try a couple days a week, and then maybe the next month we'll add another day, or whatever it is that helps the kids be comfortable, because we don't want this to be a jarring process for them. And it also lets the parents practice rebuilding that trust. And let's see, well, dad can't, dad never gives him a bath. Well, nobody can, but he's got to have the chance to show that. So let's address whatever the concerns are. Let's address them. We'll figure out plan A. We'll come back, see what needs to be tweaked. And then the next month we may do something else. And that's another thing that's unique with collaborative, is it can take however long it takes. It's up to the clients. 90 days is the shortest we can get it done. And some people that's important. Some people, I've had some take 6 months, 6 or 7 months, because the clients were in a different place. They needed more time to process. They needed more time to work through some different things. And so we honor wherever they are. And so ultimately, what we have is a plan that's going to help their family gently recalibrate to what the new normal is going to be. What I see is the healing that goes on over that process. As we start chipping away one issue at a time, start finding this agreement again, you can almost see the body language of clients as they start to relax, to know this is possible, to know that they can problem solve together. Because again, if they'd been really good at this, they probably wouldn't be in my office. So they have to relearn some of this, learn how to work together again, learn how to work together without the conflict that brought them to the divorce in the first place. And communication is a big part of it. And when we talk in the collaborative meetings, we agree that it's going to be future focused. We can learn from the past, and if there are repeated issues that kept coming up, you know, we kept hitting this wall every month, every year, whatever it is. Well, then let's address that and find a better way to handle that issue, but we're not going to go back and solve the past. So what we focus on is figuring out how to do it better going forward. We are very practical and it's very solution focused. There's no right or wrong. There's no win-lose. We sort of acknowledge the messy humanity that we all have. And so we want to look at what can we do better? What would make this feel better for you? What would make you trust the other person more? What would make you feel less anxious about the kids? Would it help to have, you know, a call, you're going to call each other Sunday nights and plan the week, whatever it is, whatever the practical solution is, that's where our focus is. And this helps them create new habits. If we're going to break our bad habits, we've got to create new ones. And we need to give them, as professionals, we need to give clients those tools. I did a talk on mediation and with a colleague, and we were talking about how we've got to bring the humanity back. You look at the legal Zooms of the world and the online forums, and that's great, but that's not going to problem solve with you. That's not someone that's going to sit down with you and travel through this journey with you and help you as a person, and not just as a client or a, you know, it's to really sit there in that humanity and help you figure out what life is going to look like when this case is done. Because that's where we can still do the good. That's the service that we can provide. We were originally counselors at law. And so from a business standpoint, bringing that counseling element back in, I think is really valuable for these clients, especially when we're working with families. I work with divorcing families, as we're talking about today. I also work with elder families. It's the same. It's parents fighting over kids or kids fighting over parents. But when we're working with families, there's a lot of good that we can do using these sort of collaborative, problem-solving, solution-oriented techniques. We're also, another benefit is that we're having real-time conversations. It's not, I'm going to send an email to the other attorney and they're going to ask their client, and then they'll get back to me and I'll get back to my client. You could have a couple-day lag time. You might get it back and forth in a day. We're sitting around the table. Everyone hears the same thing at the same time, so no one is in that lag time creating their own conversation in their head. So it's right there, and we can deal with misunderstandings right there in real time, because sometimes we say things inartfully. Everyone has had our foot in the mouth at some time, and we will again. So let's deal with it. And let's talk about a better way to say something, or we talk about when somebody puts their foot in their mouth, can you ask rather than accuse? Instead of jumping to conclusions, assume good intentions. Let's agree that we will assume the best and ask for clarification rather than just jumping down that rabbit hole. And as I said earlier, we're modeling, as professionals, modeling these positive techniques. So when does collaborative work? And there's a misconception that collaborative works when everybody already agrees on everything and everything's hunky-dory. Well, first of all, if that was the case, they probably wouldn't be getting divorced. But collaborative works whenever there's going to be a continuing relationship beyond the dispute. They don't have to agree. They don't have to like each other. They need to want to do better. It's very common to have people come in and say that, you know, my parents got divorced when I was a kid and it was awful and ugly and I don't want my kids to feel the way I felt. So as unhappy as they may be with their spouse, they don't want to do that to their kids. They want a better way. Collaborative can be done. The normal rule is that we're all together around the table. It doesn't have to start that way. What makes it collaborative is the agreement to not go to court. And so it may be where we do some negotiation between the attorneys before we get into that joint meeting. I think the joint meetings are important because it allows us to do that communication work. It allows us to work with them on how they're going to co-parent. But it doesn't have to be. The values that clients need is to be able to identify and work for their own interests, that they want to be in control of the outcome, that whatever the decision is, they want to work towards finding it themselves and being a part of that decision, rather than I'm not agreeing to anything until a judge absolutely tells me I have to. But if they want to be part of that process and part of the solution, then collaborative will work for them. And the thing is, they have all of these professionals supporting them. We're there to guide them. We're there to teach them about the process. We're there to lead them through and advise them and help them figure out how to do this, how to sit down and work with this person they haven't been able to work with as well. Usually there is more agreement. I see this in collaborative, I see it in mediation. Usually there's more agreement than we realize because we tend to make a lot of assumptions about the other person. And there's the old adage about what happens when you assume. So usually we've had these, in preparation for a fight, we've made all of these assumptions that aren't usually accurate. It saves time and money. That's another thing that I'll tell clients that they'll come in and say, well, I want to do this. I'm not sure if my spouse will. Well, one of them is going to be that this will get done faster, usually, depending on the clients, and usually will not cost the same as going to trial. It's a much more efficient process. There's a lot less collateral damage. Emotionally, financially, there's all of these things that the adversarial process inflicts on us. A friend says there's no long-range missiles in divorce. Whatever you do is going to hit you to some extent, because whatever you do to your spouse, you're doing to your kids. And so usually people don't want to do that. And the way to avoid that is to take the higher road. When we need some creative solutions, I've had some where there's just something quirky. And so because we have these other professionals available to us, we can bring them in and find some, how are we going to get this house refinanced? Because there's a mortgage and a home equity loan on it. And so the money's there, but how do we get it out? And so we find the financial professionals that can help us figure out how to move things around, how to get done what we need to get done. So we have a lot more leeway that way than a court's going to. And clients need to be able to negotiate based on their interest. It's not the person that says, I don't care if I win as long as they lose. Okay, well, that would be a tough one for a collaborative. But if you can, I just want to move on with my life, one way or the other, that we can work with. That's about the point that I need you to be at. Because the rest of this stuff, the process figures out. And what amazes me are the clients that come in, and the first meeting, we may have tears. And by the end of the process, they're walking out talking about the kids' schedule for the week, or they're just, you watch the healing start. You watch them get to that other side where they can move forward. So what happens if the process breaks down? And I will say that I have not had this happen. I've had some people reconcile. I had a case where we thought it was going to break down because they absolutely wouldn't agree and really being obstinate on both sides, and we couldn't figure it out. And then we got an email one day saying they decided to get back together. I don't know that that's terribly common, but it happens. If we have a process where there is either one issue or multiple issues that they say we can't work it out, we've got to go to a court to decide. It's voluntary. This is a voluntary process. The client signed in the agreement that they understand this is voluntary, that they're potentially giving up formal discovery, court hearings, things like that. If they choose, nope, I can't do it, I don't trust them anymore, whatever it is, then we're going to court. If that happens, both attorneys withdraw from the case and they have to find new counsel. Now, it doesn't mean they have to completely start over. If they say, look, we figured out 3 of our 5 issues and we're good with that, then they don't have to redo those 3 issues. They can just go to litigation on whatever is remaining. And we will help them transition. So, you know, if that happens, then I'm going to take my client to someone who does litigation and get them up to speed on the case and help them understand where we are. It also says in the agreement that if that happens, nothing dramatic happens for 30 days. We're not going to file anything for 30 days. Any temporary agreements stay in place for 30 days. There's just sort of a hold to allow everybody to make that transition. So there's no one's going to do anything crazy. If there's an abuse of the process, then it terminates. An abuse of the process would be, you know, taking the kids and leaving the state, hiding financial information, any of the unethical stuff, not disclosing, not being honest on where assets or debts are, hiding money, things like that. If we abuse the transparency and integrity of the process, then both attorneys will withdraw and they'll have to find new counsel. Now, I will say there are cases where if one of the collaborative attorneys has to withdraw for something that isn't about the process, you know, medical emergency, something like that, they can be replaced by another collaborative attorney and the collaborative process can go on. So this just refers to if everybody says, nope, can't do it, got to go to court. So they always have that option. They will go to the court on whatever issues they have to discuss at that point. And we will help them through the transition. And it says in there, we're not going to call the attorneys in to testify. We're not going to call our other collaborative professionals in. It says in the agreement, other than to say, similar to mediation, the collaborative process occurred. We were not able to find a final resolution. That's the only thing that goes forward. So from an ethical standpoint, we as attorneys still have the obligation for zealous representation. It's a little bit different. How we do that is different in collaborative. I still have the obligation. My client says, these 3 things are just really vitally important to me. Then my job is to do everything I can to help that be a part of our final solution. I am not required to be a jerk about it. I mean, you can do this within the process because when we go in there, we're talking about it in terms of needs, in terms of interests, and, you know, why is it important that you have the kids on these days? Well, let's talk about that heart reason, because the heart reason, the why behind why these things are important for us is usually far more empathetic than just the position statement. So if I can go in there and explain the why behind it, I'm more likely to get my client what is important to her because I've taken advantage of that empathy and compassion and understanding what's important to the spouse across the table too. And so we find things that meet both of their needs. And then we've set them on a better footing because now they understand why these things are important to each other. So we're still meeting their needs and meeting that zealous representation, but using the power of compassion and empathy and integrity to do that. The clients go into this with informed consent. They know that the attorneys will talk to each other, that everyone around the table can communicate. It's very common to just send out group emails, especially when we're trying to schedule. Or we've collected these documents so far, just send it to everybody in the group. But the clients give informed consent. This is considered limited representation when you do these collaborative cases because we're not going to court. And so they agree up front that this is how this is going to be. We agree to this level of communication. We agree to sharing of documents, all of these things. We still have the confidentiality if the client wishes for that. They are still free to say things to their attorney that they don't want carried into the room. So they don't lose that attorney-client privilege. We have the same rules in the agreement. If you receive something in an email or something that is privileged that you shouldn't have gotten, then you need to notify your attorney or notify the team. And we agree up front that no one's going to take advantage of anything like that. But they do have that right to confidentiality and to work through some of those issues privately. We also need to take into account the ethics for every profession of origin, because the financial people that come in have their own professional ethics and regulations, as do the mental health professionals. That's one thing in the agreement that we have to point out, that for our mental health professionals, they are mandatory reporters. So if something comes up that would amount to child abuse in there or something like that, they have that obligation to report that. So we each have to honor the standards for our professions of origin, in addition to the collaborative standards that we agree to when we sign on. So, okay. So really, to make this paradigm shift, and it can be tough for some people, it was a glorious find for me, because I am a fixer, not a fighter. But for some people, making this paradigm shift, we are going from an adversarial situation to something that's cooperative. And that can be a tough jump for some people. Although when I did my collaborative training, I was amazed the attorneys that are, I just want to be able to help my clients. I want to be able to fix stuff. I don't want to have to go through these sometimes unhelpful hoops that we have in the adversarial process. We're shifting from focusing on past wrongs or past fault to looking to the future. We waste a lot of time worrying about what went wrong instead of focusing on what we can do better to make things right again. So collaborative focuses on the future. We get off of the positions, my way versus your way versus the highway, and we talk about relationships. You're still going to have to work with this person. You are still both going to be parents to your kids, and your kids are going to love both of you, and they get to love both of you, and they should. You have grandkids someday, they're going to love both grandparents. That's a legacy for each of you that you're always going to share. And so we want to get that relationship to a healthier place where, if nothing else, at the very minimum, we can peacefully coexist and not drag the rest of the family into whatever differences we have. We're shifting away from blame and looking at impact and ways to improve. And we're shifting from a win-lose scenario to win-win, or how I like to tell people is it's success. Because if it's win-lose, someone has to win, someone has to lose, but the irony of that is, even the person that wins, if those are your only two options, at some point you're going to switch. So even if you've won this round, so to speak, down the road it may go the other way. When we treat it as success and we're looking at possibilities and we're looking at healing, that's infinite. Everybody can succeed, and it's a more evolutionary track. So we made our progress here. We were able to get through the divorce. We were able to decide our financial distribution, our initial custody and visitation for the kids. We've learned how to work together. We've learned to communicate better. And so 6 months, a year, 2 years from now, when we have another disagreement, which you will because we're human, means something's going to come up. But now we have those tools to draw on. Now we know what that success feels like. And because in our collaborative process, we talk about communication, now we're going to use those tools to keep us on track. So it's not just always that trade-off between win or lose. Success always keeps moving us forward. Because every time we solve a problem, we now have tools to solve the next one. So hopefully we're getting better each time that comes up. That's where we're trying to get people. And in the old paradigm, we are stuck in the past. It is all about what happened before and who's to blame for it and who's going to do what to make up for it, but it's very past focused. In collaborative, We're looking at the future. We're trying to recalibrate the family to their new normal. We want them to be healthy. We want them to be stable. We want them to be able to start moving forward and have an idea, not just what life looks like when the decree is signed and I get that back, but what does it look like 6 months from now, a year from now? You know, where am I living? Am I in a house, my apartment? Am I working towards a house? How are the kids doing? How are we treating school stuff together, or visitation, or being able to be flexible when things come up? There's a lot of misconceptions about divorce and what that decree means. And, well, what if 6 months from now we need to do something different? Well, if you both agree on the something different, do it. The court is not invested in you fighting. The court would much rather you manage your lives. And that's what we try to tell clients, that we're going to get you to a place where you can work together, where you can manage your family, manage your lives, and move forward, and not have to keep running back to the court to beat somebody else or to get the win. We want to give people the tools they need to move forward. So do we have questions? Okay. Okay. If we have questions, this would be a great time. Yeah, so she asked if there are resources. If you want to know more about collaborative, the Iowa Association of International, IACP, International Association of Collaborative Professionals. If you go to their website, they have a lot of resources about collaborative. And on a national scale, primarily it started getting really used in divorce, because that was the pain point, was these families that really needed a better way to do this. There are areas that use collaborative in business relationships, because you can privately work through these issues. You're not dragging everything into court. You're not taking the time or expense to do that. You have the privacy, you have efficiency. Another topic that's been coming up a lot is using it with elder families, because they're so similar. The issues we deal with family is to branch it into other areas. So the IACP website, which I think is collaborativedivorce.com, I'm not positive off the top of my head, they have a lot of resources and a lot of stories and a lot of links to how collaborative law is being used nationally and internationally, all over the world. Our website is iowacollaborativedivorce.com, and we have some more information. We also, there are trainings periodically, so if you have interest in being trained in collaborative, you can contact me and I'll get that passed along to the right person. Let's see. Stu Webb and Ron Owski were kind of the fathers of collaborative divorce. They're up in Minnesota. But either of those names, they have written books on collaborative that are really great, that help explain how we do this paradigm shift, how we work as servants, as those counselors, to help families get to a better place. Yes. Yes, Bill.
Sorry, I can't get on, but would you say that the outcomes in the longer term are better than going through this process?
Oh, absolutely. Yeah. And that's why I love watching. I had one couple that before we signed the decree or signed the stipulation, went on vacation together one more time with the kids last summer. And just because they wanted to give that to their kids. And it's interesting, the trend I see when divorce clients come in tend to be after the holidays, or after school gets out, or at the end of the summer, or things like this. And it's not, and the joke is that it's after the holidays because everybody blows up, and that's not usually what it is. It's, we want to get through one more X for the kids before we start this process. The holidays, get them through the end of the school year, or get You know, the oldest one graduates high school in May, so we need to get through that. We have to get through something because they're trying to be mindful about the process. They don't want to implode their families. We have seen the horrible divorces. We've seen the War of the Roses and the incredible damage that can be done. And they don't want to do that. But they don't know how. So coming to the collaborative, there's usually kind of that sigh of relief that this is possible. It is possible to get through this without attacking and killing my spouse. Because it's like I don't want to be married to him, but I don't necessarily want to rip him to shreds either. I just want to be able to, I want to be able to be stable moving forward. So I want to be able to take care of her. I just can't go bankrupt doing it. Well, no, because that's not good for anybody, and that's not good for your kids to see that either. So we don't want to do that. And they go, and they sort of sigh with relief. So it is, because they get to see that they're both going to be okay. And that's what we care about. That's really what keeps us up at 2 a.m. is, am I going to be okay? What's life going to look like? Because it's all unknown, and we've seen all the ugly, and that's what we're afraid of. And so this removes that. Oh, cool. Can I make that window bigger? Oh, there we go. I was just doing one word at a time. Yeah. Okay, what happens if afterwards it was determined that someone was not entirely truthful about finances or the like? So if they don't find out, if that doesn't come to light until, I have not had this come up, so if that doesn't come up until after everything is finalized, if it comes up, hopefully that would come up at some point before the final decree is signed. And then that would be something that would violate the process, and that would send them, that would sort of suspend everything until they could get into litigation on that issue. It's more challenging if the decree is signed, because I just looked this up the other day, that they can't, the financial settlements are done when the divorce is done. That's sort of the short answer. The tricky thing, you know, you'd like to think they would come back to the process, or if there was something that they were, hopefully that would come out ahead of time. And we're pretty diligent of still going through where everything is. And the attorney for each side has an obligation to not let their clients hide things. I mean, you have that due diligence too of, are we listing everything, or they think there's something else? We need to hold them to that, hold our clients to that standard as well.